May I then bring together the way in which I would answer that rhetorical question asked by the Court of Appeal about why use the word highway when this jeopardised importing the Baird concept?
The word highway first appeared in the 59 Act in this context.
In this context, yes.
Yes.
And I don't want to, in this summary, skip out anything I've said, but the main points are these. First, of course, it's misconceived to start from the premise that the word highway has the meaning the Court of Appeal thought that it had. Secondly, in any event, the draftsman hasn't used the word highway. What has been used is a composite expression which has no precedent in the earlier cases, and which we say carries the clear meaning described and explained by the arbitrator in his award at paras 108 to 111, which I showed you. Thirdly, the draftsman has deliberately departed from the operative verb vest by choosing the verb transfer. My Lord Carnworth referred to subsection 4 of section 265, where transfer is used in the same provision as the verb vest. You can actually find other provisions in section 265 and article 2 where the same is true. Vest is used in both provisions. I accept that. My point is that the operative verb, the verb which does the lifting in section 265.1 and in article 2.1 is transfer, not verb. That is the verb used in the active voice. Fourthly, the draftsman has deliberately omitted those words which are found in section 263 about maintenance and repair, which provided that crucial link between the duty and the extent of what vested. That big clue about the limited extent of what should vest under section 263, which was so influential in the 19th century, perhaps over-influential, is completely missing, and deliberately so. Fifthly, the draftsman has adopted a structure in which paragraph A only adds anything to paragraph B if it describes the property, including land, on which the highway is situated, with paragraph B doing the different job of describing property, including land, which is remote from the highway. Sixthly, the draftsman has included provision for the incoming authority to agree that the outgoing authority should have back any particular piece of property in case the default provisions don't work suitably in any particular situation. And seventhly, the vesting provision in section 263, which carries the whole case law about the Baird concept, is explicitly disapplied from section 265. I ask again, how much clearer did the draftsman need to be than that? My lady, I have also in my case developed some broader points about the policy and purpose of section 265, as well as the practical implications of the competing interpretations. And this is paragraphs 23 to 37. As we've proceeded this morning, I've covered probably all of them in one way or another, so I'm not going to go over those orally, if you'll excuse me from doing so. I invite you to take them as read. Can I instead just locate for you some of the critical points that were made by Mr. Mayle in his award, going back in volume in Appendix 2A, the internal numbering 78 to 80, paragraphs 100 to 107. The memory stick number is 215 to 217. And he reflects in this section on what he calls in paragraph 100 the interpretation, which interpretation produces the more rational and therefore the more likely scheme. So, my lady, you recognise the exercise he's embarking on is to test the coherence of this provision under the competing interpretations, which is an orthodox approach to statutory interpretation, as indeed contractual interpretation. In this respect, as a matter of fact, before the transfer order, there was one public body, i.e. the former highway authority, which owned all the land, including the subsoil and airspace comprised in the relevant GLA road. After the transfer order on TfL's case, the effect of paragraph A is that there would still be one public body, i.e. TfL, which owned all that land. In contrast to on the council's case, after the transfer order, there would be two public bodies owning the land. TfL would own the top two splits and the necessary land. The councils would own the subsoil below, the top two splits and the airspace above. I find it hard to see why Parliament would want to replace a straightforward, certain and simple scheme, i.e. one public body owning all the land comprised in the relevant road, with a more complex and potentially uncertain scheme. Two public bodies owning different interests in the land, the extent of which might be the subject of dispute between them, either as to what was necessary for highways purposes in 2000 or in the years to come, when what is necessary for highways purposes might change. With all due respect to the councils, I cannot see what rational purpose is served by there being two public bodies owning different layers of what was formerly owned by one single public body. In so saying, I have not overlooked the possibility that the subsoil and airspace, which the councils say did not transfer under A, might transfer under B. If that was the case, then in practical terms there would be nothing between the parties for me to decide. But I note, and he refers to the fact that the councils themselves were saying that there would be different considerations. So that relates to the question my Lord Reid was asking before lunch. So he continues, despite the potential operation of B, the council's case does involve the creation of layers or slices of property interests above and below the GLA road, which slices or layers or slices did not exist before the transfer order. And he recognises that is only one factor for him to examine. Nevertheless, as you've seen from the passages of his award that I've shown you previously, he regarded it as an important factor. May I then, I think I've read to you what follows in 108 through to 111. I think I can now go to 115, where he reflects on the underlying purposes of the transfer order and the Greater London Authority Act 1999. I turn to consider the purposes underlying the order and the Act to see which interpretation is more consistent with those purposes. As to the provisions of the order, it seems to me that the purpose underlying the order was that so far as the GLA roads are concerned, TfL should step fully into the shoes of the former highway authority. It strikes me as unlikely that Parliament intended that if prior to the transfer order there was one authority owning the property, it's the same point being made again. And I think I've shown you paragraphs 117 and 118. Then at 151, he refers to an argument that had been made, that it's difficult, this is now internal page 92, memory stick 229. He refers to an argument made by the councils that it's difficult to conceive of a justification for TfL's approach in terms of facilitating the operation of the relevant highway as a GLA road, when Baird secures the vesting of what is necessary, and paragraph B transfers other property held for highways purposes used in relation to the GLA road. Again, I respectfully disagree. A simple justification for TfL's approach, it is that TfL should step fully into the position of the former authority. TfL's case achieves that result. The council's case either does not do so, or, depending on B, may not achieve that result. Whereas I can see justification for TfL's approach, I cannot see a justification for the council's, and he refers to the raft of flying freeholds, as he calls it, again. And the points that we have developed in our written case in paragraphs 23 through to 37 are really a development of what the arbitrator has there said. So unless, my lady, you think it would be helpful for me to take you more fully through them, I think I can skip that exercise probably. The next submission I must make relates to that case of Bayliss, which is the nearest thing there is to an authority dealing with the question of what vests under section 265. This is in the authorities volume at, made a note of it, thank you, 27, it's volume 3, tab 27, memory stick 1992. And I must start, I think, by locating what the deputy judge said, which is at page 2003 in the memory stick numbering. He said, two consequences, does your ladyship have this at the foot of that page? Two consequences flow from the land becoming part of the highway maintainable at the public expense. First, public rights of way exist over it. Second, under section 226, and then there's that vesting provision, which is now 263. The reason why the surface of the land vests in the highway authority is that it's necessary for it to do so in order that the authority can perform its statutory obligations to repair and maintain the highway. As I have said, the highway was designated a trunk road on the 1st of April 1977. The effect of trunking a highway is that the highway vests in the Minister, now the Secretary of State. The extent of that vesting is such part of the land as is necessary for the highway authority to perform its statutory functions. It has been described as the top two spits, and there's reference to it being a determinable fee simple. And that's it. That is said. Now, as a preliminary point, on a first reading of that, it's not actually 100% clear whether what the deputy judge says at the top of 2004, when he says the extent of the vesting, is directed to the vesting under 226 or the vesting under the trunking provisions. I think I accept, probably, the better view is that he is describing what happened under the trunking provisions. It's not absolutely clear, but I think that is probably what he is there doing. However, and this is the point Mr. Justice Mann drew attention to at paragraph 34, manuscript page 174, the point which now arises could not have arisen, because the only interest that the outgoing highway authority had acquired was in the top two spits. There was never going to be a way in which more than that could pass to the Secretary of State under the trunking provisions. And that really is the short analytical answer to all this reliance that's made on Bayliss. It isn't dealing with the situation which we have to grapple with. And I have to say, in addition to that, so far as one can tell, what the deputy judge said here is not only obiter, but it is completely, it's not argued. There's no sign that this point was argued. So if I may say so, this, not only is this a weak thread on which to hang any conclusion, I respectfully say it is not actually a legally admissible thread at all. It doesn't even have persuasive authority, because there's no sign that this point, which was obiter, was actually argued. Lady, then, let me move to the next stage of my submissions, which is to cross-refer what I've been saying about section 265 back to Article 2 of the 2000 order, to do a safety audit in case there is lurking in Article 2 some particular provision which means that the analogy with section 265 is false. I can tell you in my submission there is no provision to falsify the analogy, but I do need to show you two distinctions, linguistic distinctions. The first means that I have to go back to start with to section 265, tab 11 in volume 1 of the authorities.
Before you embark on this, could I just put to you a point that just occurred to me in relation to 265? If one looks at B1, it's dealing in Roman 1 with property vested in the former highway authority for the purposes of their functions in relation to the highway. I'm just wondering, could there be instances where the highway authority was vested in subsoil for purposes other than highway purposes?
The honest answer to that is I don't know. But I think, and this is what the arbitrator inferred from the response received from the councils on this question, is that there might be.
Yes, I was wondering in relation to drainage, for example.
Yes,
but I don't know. But
that might be an example.
Now, how does your submission cope with that possibility?
Well, my submission is that we don't get as far as paragraph B, where what we're looking at is land under the surface of land covered by the right of way. If the public has a right of way in relation to a route, and the Highways Authority has any interest in relation to the land covered by that route, that is what passes under A.
Yes. So in the example that I was putting to you, the subsoil would pass to TfL, notwithstanding that it was vested in the former Highway Authority for the purposes of a different function.
Yes,
Is that right?
right. If that's what applies, if one has to rely on B, that would be right.
Can I just be clear? You're saying that A would cover interests held for non-highway purposes if they're physically under the line of the highway.
The arbitrator deals with this, and I suggest correctly, that there does come a point at which the example given in argument was a shooting range. It seems that underneath one of the highways in the Corporation of London, there's actually a shooting range. The two shooting ranges.
Yeah.
I don't know how you get into them. But it was said, well, surely it couldn't be the case that the shooting ranges would pass. And I've accepted that the shooting ranges wouldn't pass on my interpretation. That's not because one is involved in the question of to what degree is the shooting range held as a function of a highway's use. It's because, as a matter of interpretation, in the same way as if you were looking at a grant, you can see that the highway does not include that land which has acquired some completely separate identity, any more than if you were to convey a street, you would be taken as conveying the houses on either side of it.
Sorry, are you talking A or B here?
A.
You're talking A.
Well, say, for example, adapting the facts of one of the cases we looked at this morning, you have a highway which is vested in the Highway Authority, and they have title to, for some historical reason, perhaps compulsory purchase, they have title to the entire vertical unit. And say they have constructed a public lavatory under the road. Now, Lee, as I understand it, on your argument, under A, there would be a transfer of everything they owned, including the public lavatory.
That is subject to two controls. The first is the one I've just indicated, that there may be cases where it's clear, because of what has happened physically, that there's a parcel of the subsoil which simply cannot any longer be regarded as highway, and the shooting range is the best example of that. But the other control is the one I showed you in subsection 5,
So you say that if in the subsoil something has been constructed which is not connected to the highway, I'd have thought a public lavatory might be an example
It's a
of that.
better example. I think, yeah.
Yes.
Then it's not carried by A.
I find that very surprising, actually.
Now, if it's connected with the highway, for example, if it is a public lavatory, then yes, that would pass under A. I would expect it to pass under A. The facts which I have thought more clearly illustrate the difference is where there is some clear structure which shows that below a certain depth you can't regard this as highway anymore because it stopped having any possible association with the noun highway, and the shooting gallery is the classic example of that. A lavatory isn't. That's the first control. But the second.
So the shooting gallery does not pass under A, even though it's part of the land which the highway authority owns.
I've accepted that, but I might be wrong to have made that concession.
I'm quite concerned that you've made that.
Yeah.
The other control.
And what about a lavatory that's been converted into a nightclub?
Well,
That's a very common example.
This is where it becomes more marginal on the arbitrator's approach, and it may well be that what it tends to expose when you look at cases that are more closely allied to a highway's use, that the concession I've made below was wrong.
Yeah.
But that takes me to the other control. If I'm wrong about that, how does Section 265 deal with unusual situations? And I hope I've indicated my answer to that. One shouldn't approach Section 265 on the basis that it had the paradigm case that the draftsman had in mind is full of these complexities. The paradigm case is the simple one, where you've got a highway and there's not much above it and there's not much underneath it. But there is the possibility of these complicating factors. How does the Act deal with that? It deals with it in subsection 5, paragraph B. It gives to the outgoing authority and the incoming authority a power to agree to retransfer property. That's how the draftsman set up the way to deal with difficulties like this. And my lady, you may question whether that was a fully sufficient mechanism to deal with a case where, as it seems to be the case in London, there's money involved. I do wonder whether the draftsman of this section understood that there could be money on the back of these points. In fact, my submission is that when you look at Section 265, probably that is far from the draftsman's mind. This section deals with the transfer of highways as an administrative matter. It assumes that public bodies dealing with each other will be able to agree sensible arrangements, so that if the City of London has a good reason for having back the shooting gallery, it will get a fair hearing from the Secretary of State if it asks to have it back. Now, sorry.
Is it possible to read in or imply, or whatever you like, into 265(1)(a) the words "as such" after "in the former highway authority"?
It would be, as long as by the words "as such" one wasn't then importing back just the top two Spitz rule.
No, I wasn't thinking. I mean, the problems in this case address a situation where the previous authority has acquired, other than by vesting under 263 or its predecessors, land, and therefore not just acquired the top two Spitz. The fact that it acquired, say, by compulsory purchase or dedication, something more wouldn't mean that it didn't acquire this highway authority if there was, it had no other statutory capacity under which it was acquiring. That's how it strikes me.
So if the "as such" dealt with the highway authority as such.
Yes. Oh, absolutely.
That might be the...
Yeah.
But I do say that I prefer the view that it's dealt with under subsection 5. That's the mechanism.
Does the arbitration provision extend to 5 or not? I mean, if they fail to agree.
It includes 5, but only to, well, I say only to this extent, that if there is a dispute about what the parties have agreed should retransfer, that could go back to the arbitrator. I don't accept that the arbitrator could say to the Secretary of State, no, you're being unreasonable in refusing to give consent.
You can't impose an agreement on it.
No. So, but, my Lord, I'm grateful. I hope for that opportunity to explain what we say are the controls that apply in this area. And I hope that answers my Lord's question.
And rising out of that, I was just reminded of what the arbitrator said about the problem of what are the flying freeholds in the hands of the authority. Because somewhere he raises a point that it's not very clear what powers they would be held under.
Yes.
Someone was trying to negotiate with them for the use of the overhanging rights.
Yes.
It wouldn't be held as under highway powers.
No. It raises a problem.
Can you remind me where that's dealt with?
Is it 118?
Yes, it's 163, where he's stepping back.
Yeah.
I'm in the darkest capacity in which the Southwark would hold their retained airspace. And at 60, he's talking about an adjoining landowner seeking to negotiate rights.
Yes. And it raises the same...
Is that a point which was addressed in the Court of Appeal or not?
No. No, I don't think it was. And there's, but the same point arises nationally, I suggest, in the context of these little bits of land that might be held after detrunking by the Secretary of State. Now, I appreciate that the Secretary of State doesn't, so much as a local authority, need a specific virus to hold land. Appreciate that, because it's an emanation of the Crown. But nevertheless, you have this odd situation in which, quite by surprise, and potentially years after the event, after a detrunking, it may turn out that the Secretary of State is the person with responsibility for some either flying freehold in the airspace or indeed below the surface of the soil. When one thinks about these issues from the national perspective, where you might have trunk roads in the middle of nowhere that have been detrunked, not in the middle of cities where these issues become acutely important, you gain, I suggest, the correct perspective on this. Section 265 was meant to deliver a clean blow. And if there are practical difficulties that result from that, in the context of these dense urban environments where it turns out there are valuable things under the ground or above them, the answer is not to adjust the natural interpretation of Section 265. It's to recognise that Section 265 deals with this problem in the specific way I've mentioned in subsection 5. And you can complain that that's not an adequate remedy. The councils can complain that's not enough, but that is the remedy Parliament has given. Yes, I was going to refer the court to two differences between Article 2 and Section 265, although I say they don't make any difference to the effect, but it's important that you should be aware of them. And I wanted to start by locating the relevant bit of Section 265. If you wouldn't mind going back to memory stick page 1531. You remember I showed you at the end of 265 are the words "and the highway and other property so transferred vest." Does your ladyship have those two lines? Foot of 1531, near the foot of 1531. And I said that is an indication that highway, the word highway, is recognised as part of the genus of property. Can I also show you subsection 4 on 1531? 132, any property vested in the minister or Strategic Highways Company by virtue of this section should be held by him or the company subject to all covenants, conditions, and so on, except liabilities referred to in subsection 2. In the 2000 order, those two bits, the bit at the bottom of 265 and Article 4, have been combined in sub-Article 5. Let me show you that. In tab 2, memory stick page 1312.
Sorry, 1312. Did
My
you?
lady, yes. Your ladyship see at the bottom of sub-article 1, those words which I showed you a moment ago at the bottom of subsection 1 of 265 are missing, but they're combined with what in section 265 is subsection 4 in a new article, Article 5, at page 1314. So it's doing the same job, but differently. But I do need to show you what's happened to the words. They have joined them up. I ought also to point out that because of the way it's being joined up, the word other has got left out. So you don't any longer have that nice, clear indication that highway is a genus of property, but I suggest that doesn't make any
But on the other hand, it doesn't refer to highway, does it?
It
just
does.
says any property.
Exactly.
Which must be an even clearer indication that
I
includes highway. It can't not
suggest
have highway.
I suggest that's right, but I thought it right to draw that to your attention. That, in that respect, the form has differed. The second respect that I've noticed in which the form of Article 2 is materially different, of course there are differences to do with GLA road and so on, I'm talking about material or potentially material differences, is that you remember that section 263 is expressly disapplied from 265. There's no provision expressly disapplying 263 from Article 2. Now, either that's for some ingenious reason that I cannot fathom, or it's because of oversight. But I suggest it doesn't affect the interpretation either of section 265 or of Article 2. Milady, the final part of my submissions is, or I perhaps should say, well, like what I'm about to say, was going to be to develop the points made in my printed case, paragraphs 46 to 47, about the difficulties when you come to apply the Baird concept. I've set them out in writing. I'm not sure actually there's much, if anything, I can productively say on top of what is there set out. I think I'm going to invite your ladyship to take that as read, particularly as it's a slightly deluxe point.
Deluxe, I like that.
And so unless there's some topic on which I can help the court further, I think I would like to stop there.
What about these nice plans?
Well,
In
what
particular, I
they are
don't
quite
want to take
nice.
up time, but I was intrigued by the drone flights within the highway corridor.
It's to illustrate, my lord, how potentially vexing the Baird concept can be, and how problematic it will be for our authority if it applies in our situation. What these diagrams show, one after the other, it's of course entirely hypothetical, but we start, my lady, this is at page 107 in the core volume. You start off with a relatively simple highway, a shallow depth of metal, a shallow depth of subsoil which is needed to support the highway, relatively light traffic, and so on. A little while later, the road needs more metal because there's heavier traffic on it. So one's had to go down deeper. There are now utilities underneath the foundations, and a subway has been built underneath that. My lady, although this is not taken from real life, these are not untypical examples of what actually happens in highways. And one then goes a little further forwards into the future, and flying over this formerly relatively simple highway has been added an elevated road. If that road were high enough, on my learned friend's case, TfL might find itself needing to compulsorily purchase the airspace which ostensibly had vested in it. And Mr. Elvin is happy for that to happen. I say that's absurd. And then
Of course he'd be happy for it to happen.
yes, but then finally at 110 you have that illustrated, and to an extent it looks far-fetched, but we don't know. It's not actually all that far-fetched to have two. You can think of a spaghetti junction type arrangement where this issue may very much come into play. You can't judge the height of what is needed for a highway by reference to the double-decker bus, which at the moment uses it.
Yeah, this is 52 bus, which I came on this morning.
I was on that very bus just the other day.
Done very well.
So that was the purpose of those illustrations, and I hope that they're helpful. But unless there is anything else your ladyship would like me to address you on at this stage,
I think not, Mr. Morshead. Thank
you.
you very much indeed. Mr. Banner? Mr. Elvin.
My lady, my lords. Can I start by just setting out what the council's submissions are as to how the scheme operates and why Mr. Morshead is making an unnecessarily complex meal of it? In my submission, the way the statute the transfer order operates is similar to section 265 as my learned friend has put forward. But what my learned friend seeks to do is to cut out the exercise in Article 2.1b, which is the inquiry which the arbitrator must undertake if it can't be agreed, as to whether property is held for the purposes of the highway function. The difficulty which arises generally with regard to this issue of the extent of property investing arises because, of course, roads, highways are acquired through a variety of means. And that is all the more so in central London, and particularly in the City of London, which, of course, is a corporation by prescription extending back into the mists of time. Highways or land on which highways are constructed may be acquired by agreement. They may be acquired by prescription under the old law. They may arise through dedication when Section 263 is triggered by the act of dedication. They may arise under Section 38 of the Highways Act, where you have a development and there is an adoption agreement with the Highways Authority. And again, that takes effect under Section 263. And it may arise, as my Lord Carnwath mentioned at the outset, by compulsory purchase, where the authority is looking to carry out a construction of a new road, a road improvement, a diversion, whatever. There will be a variety of circumstances as to what property is held by the local authority, and there may be cases, self-evidently, where the property that's held by the authority is purely for the highways function, and there'll be some where it isn't. And our submission is that the way the order works is that under 2.1a, what was described by Lord Justice Fry as the zone of ordinary use, that is the top two splits plus necessary airspace and subsoil, which is a flexible, not a defined concept, so it changes over time, vests. Then you ask the factual question, once you've got over what is absolutely necessary for the functioning of the highway authority, you then ask the question under B, what other property is needed? And the interesting point, which the Court of Appeal noted, was the word property and land only comes in Article 2.1b and Article 3, which contains exclusions and explains the application of 2.1b. So A vests, we say, the zone of ordinary use of the highway. B then vests everything else which can be agreed or determined by the arbitrator to be necessary for the function of the highway, which may include the airspace, it may include the subsoil, but it's a factual issue. But it's meant to cater for the variety of circumstances in which land is held, and is held in layers in London, regardless of what the situation is elsewhere. This is a London provision.
So can I ask, by way of illustration, if at the moment the furthest up you need to go in the airspace is the upper level of the roof of a double-decker bus, for example, but in the future there might be flying cars or drones that are large
Or
enough to
even
carry
worse, driverless cars.
Right, yeah. Well, I was thinking in terms of the air. If you had drones, for example, that were large enough to carry people, then then presumably, well, is what is transferred by the order fixed to the height of a double-decker bus, or could it in future extend much higher up if modes of transport change?
It's where one of my learned friend's points in my submission is incorrect. The authorities make it clear that it's not only a terminable interest in land, it's also a flexible one without precise definition. I don't suggest for a moment that it became fixed by virtue of the use in 2000. It vests as the zone of ordinary use, to use Lord Justice Fry's expression, and that will change over time, just as it wasn't necessary when double-decker buses were first introduced in the 20th century, well, probably late 19th century, actually. It wasn't necessary to vest further property in the Highway Authority. It simply said this was the zone of ordinary use, accommodates the ordinary usages of the highway. And there are...
Did that include trolley buses and the overhead wires associated with trolley buses?
Yes, it would have accommodated those. And the point is, it's a flexible concept, and it was deliberately said to be so because it's tied to the function of the, if I call it the Highway Authority, it would be the board, the vestry board or the district board at the time. But it's flexible, and I don't therefore accept my learned friend's submission that it crystallised in the sense of fixing physical dimensions as it would have been in the summer of 2000. What it does is it gives the highway zone of ordinary use interest to the new Highway Authority. That is therefore flexible and may change over time. Just as if you are Highway Authority and you have the top two spits ordinary zone vesting, you don't register that under the Land Registration Act 2002. It's an overriding interest in paragraph 5 of Schedule 1. You would.
Sorry, could you say that again?
Under the Land Registration Act 2002, unless the authority has acquired the whole of the freehold, which it may do on a CPO or by agreement, but if it hasn't, you do not register the top two spit zone of ordinary use. It's an overriding interest within paragraph 5, which is public rights of Schedule 1 to the Land Registration Act.
Do we have that in the...
You don't, but I can provide it.
So sorry, Schedule...
1, paragraph 5 of the 2002 Act.
Equally, going down the way, if you decided, for example, that a pedestrian underpass was required, then you don't need any additional title to the land if you already have you're already vested in the highway.
To turn the point round the other way, one of the difficulties my learned friend had, and in explaining it earlier this afternoon, is the question about the layers that exist already. And the problem with my learned friend's argument is he says basically you should transfer the title that the Highways Authority has, regardless of the fact that it may have other incidents within it which are not directly connected with the function of the highway, which is what B is concerned with. Our submission on that is that problem simply doesn't arise because you take the zone of ordinary use under A, you then have the inquiry as what's necessary for the functioning of the highway as a GLA road, which is a perfectly sensible and rational distinction. My learned friend says, oh, well, you can't create new titles, transfer doesn't mean that. All of that was very interesting, but it doesn't apply here because Section 408, subsection 7 of the GLA Act, and I'll give you the reference in a moment, allows transfers to include the creation of new interests. There's a specific power in the GLA Act, which is, I'll get the right volume. It's volume 2 of and it is tab 14, and the relevant provision I need to take to is at, thank you very much, 1635 of the electronic pagination. And the court will see at 4087 that an order under subsection 1, which is the provisions for transfer, which is the power we're dealing with here, may make provision for the grant of creation of an estate or interest in or right over any other land or property, the grant of creation of any other rights. So the point that the then Mr. Justice Stanley Burnton was making in the Lord Chancellor's case doesn't apply here because there's a specific power.
Yes, one would assume that it would be, you would find something to make it clear that's what's being done.
No, but my learned friend's point was predicated on the point that transfer couldn't include the creation of new rights. That is not the case in the 1999 Act.
Is there any corresponding provision in the enabling powers behind the trunking? Is there?
I don't think so. I'm going to take you to some of the provisions in relation to trunking in a moment because they go to one of the other submissions my learned friend makes, which go to the heart of his distinction between what he regards as the application of Bird in 263 and the non-application of Bird in 265. Well, let me prefigure it.
Sorry, but what are you saying? You're saying that this order should be
construed as... My learned friend says transfer can't include the creation of new rights as a matter of language and as a matter of the statute in the Lord Chancellor's case.
I can see that doesn't apply.
My point is a simple one. It doesn't apply to transfers under the GLA Act, which can include the creation of new rights and new estates. All I'm saying is that his point doesn't help you.
It may make provision for. You're saying this has made provision for.
No, I'm simply saying that...
I know what you're saying, but I'm trying to see where it takes you.
Yeah, well, the question is, where does it take my learned friend?
But it may not take either of you anywhere.
Well, that's what I'm suggesting. It doesn't assist. And if I can just add to that something I was going to make later, but I'll do it now. Lord Herschel, in the Baird case, didn't seem to treat transfer and vesting as any different. If I can just give you the reference, it's his speech in tab 18 of bundle 2, electronic page 1826. It's the...
So sorry, what's the electronic number?
I'm sorry.
1826.
1826. He says, and this is the bottom third of the page, having quoted section 149, all that seems to point to the surface use of the street and nothing more. I'm unable to see why it should be supposed to transfer to and vest in the urban authority. So he seems to regard the two as...
Well, it's quite a useful passage, that, because he's there dealing with the problem of the fact that you're vesting the highway doesn't cause any problems in relation to sewers underneath, because they transferred under other powers. And
Indeed.
so, to that extent, it sort of deals with that problem.
Yes.
Again, quite where it takes you, I'm not sure.
In my submission, the issue of transfer is simply a red herring in this case. If I can come back to the structure of the provisions, as I was submitting, Article 2.1a transfers the zone of ordinary use, the top two spits. B then allows the transfer of any other land held for functional purposes to the Highways Authority for that piece of road. So if airspace, subsoil are necessary in that case, then or are held for that purpose, then they go with the top two spits under A. But that, my learned friend seeks to sidestep that factual inquiry, which could be important in a large number of cases, because the question is whether it has a functional link to the highway. If my learned friend's approach to the matter that highways is simply a species of property like everything in B, then A wouldn't be needed at all either for that reason. You could simply transfer it under B, because self-evidently the zone of ordinary use would be used for the function of the highway.
And you're going to come to the question under what powers the flying freeholds are held.
Well, in my submission, that issue may be resolved by B on the facts of a particular case. The problem is, my lord, is there is a problem in any event with that issue if you're regarding that as transferring as a single title, as my learned friend seems to submit. He says, well, an inquiry can be made and there may be factual circumstances that the arbitrator recognised where matters such as the shooting gallery, lavatories under the road, nightclubs, whatever it is, can be excluded. But it's difficult to see why, if he is treating highways as meaning the title under which the Highways Authority holds the highway, which he appears to be, because his submissions are based on not dividing up that title and the inconvenience that would arise from creating new layers. Well, that problem cuts both ways in my respectful submission, and that is precisely what B was there to resolve. B also has the exclusion of the matters in Article 3. Certain items are excluded from the B transfer if A transfers more than the zone of ordinary use. 3 can't apply because 3 doesn't qualify A, it only qualifies B. So there are problems in my respectful submission with his approach, because the exclusions, if A is wider than we submit is the case, the exclusions don't bite on it.
So are you saying that, although in response to my questions about lavatories and nightclubs and so forth, Mr. Morse had made a concession that they wouldn't be carried by A, when you look at the language of A and compare it with B, the concession doesn't actually make sense.
Doesn't.
And in order to resolve the problem, you need to read A more narrowly as carrying what is required for the ordinary use of the highway, and B then cuts out it then severs out of your title, for the purposes of a transfer, things like shooting galleries and nightclubs.
Because you can't link it functionally to the use of that particular GLA road.
Yeah.
And that makes a perfectly rational scheme, because it allows everything that the Highways Authority needs for the highway to be transferred. And it's important in this context. I'm going to go to the documents in a second. But just to remind oneself what the GLA Act and the provisions of the order were seeking to do. The purpose of the GLA Act was to constitute TfL the Highway Authority, and to constitute the Highway Authority for GLA roads, that is to say London's strategic road network. And its functions are in essence as Highway Authority no more and no less than the Highways Authorities that my learned friend pins his submissions about 263 to. The GLA Act isn't making TfL a sort of superhighway authority. Of course, it has other transport functions in relation to the underground and rail and such other matters. But as highway authority, it is brought within the definition of highway authority in Section 1 of the Highways Act. And the purpose is that as highway authority, it regulates and maintains the GLA roads within London, which is precisely the function that was being focused on in the Baird line of cases. And in my respectful submission, looking at the function of the GLA Act being conferred upon TfL, it is materially identical to the 19th century functions that formed the basis of the Baird line of authorities. And secondly, for reasons I will develop in a moment, in my respectful submission, 2651A is the equivalent Baird-based provision for trunk roads. Trunk roads are no different in the sense of they're being maintainable at public expense than any other road. The difference is the minister, and now some form of special corporation, but the difference is primarily the minister is the highway authority directly for trunk roads, and indeed for special roads, i.e. motorways. You don't have the provision here because my learned friend developed his submissions orally, but I will bring section 34 of the Highways Act along in the morning, if that is convenient, or have it sent electronically, which makes it clear that trunk roads are highways maintainable at public expense. So the omission of those words from section 265 goes nowhere, because the Secretary of State is holding highways maintainable at public expense if you look at the Act as a whole. I said I'd come to the rationale for the vesting of GLA roads and indeed the creation of TfL. Can I ask the court to go back to bundle 2? And can I take the court to the context in the explanatory notes in order to understand context and purpose? The explanatory notes are also in tab 14, as is the 1999 Act. They begin at memory stick page 1647. And if I could ask the court to go to 1649 under the headings of transport as functions of the GLA. And in paragraphs 20 to 24 of the explanatory notes, it's explained what is proposed by way of transport strategy, vesting of transport in London into a single body, TfL, which replaces London Regional Transport and the like. But then, as Highways Authority, I draw the court's attention to paragraph 24. TfL will be responsible for road maintenance and traffic management on the GLA roads, which will comprise the most important London roads. And then regulation of taxi cabs and the like. So that the role of TfL as Highway Authority is, as I say, materially the same as that of other highways authorities and the highways authorities in the 19th century. The specifics in relation to highways are dealt with in the explanatory notes, and we've quoted these in our written case, but the reference is at page 1703 of the memory stick. (376), importantly, Parliament is legislating in this Act against the background of existing highways law. No comprehensive statutory definition of a highway. Concept of a highway long predates highways legislation. Then there's the common law and the reference to the right to pass and repass. The Highway Authority is the body responsible for maintaining the highway where it is a highway maintainable at public expense. So it's quite clear from that paragraph a number of important matters. One, this is legislated for, the legislation is made in the context of the pre-existing legislative history of highways. And secondly, it's making the point as to the responsibility of the Highway Authority, which again highlights the point of commonality between the Highway Authority in the shape of TfL and other highway authorities, including those given those responsibilities in the 19th century.
I mean, that doesn't support the Court of Appeal's definition of highway.
Well, except that my learned friend has to accept, as he does, that highway is used in a variety of senses and is sometimes used in the physical sense and not simply the incorporeal right to pass and repass. But what it does make...
No, sorry, I just put you, it doesn't support the Court of Appeal's definition. I mean, where that takes us is...
And they define it as a way over which all members of the public have the right to pass and repass.
That is true. But the important point, my lady, is that it's not seeking to depart in that paragraph. It's not suggesting that Parliament's intending to depart in the bill from established concepts. It's simply setting it in that context. I take my Lord's point, but in my respect, it doesn't go anywhere.
While we're on it, you may find it difficult to defend that part of Lord Justice Richard's judgment as it stands.
Well, my submissions in the Court of Appeal, as I asked my learned friend to read out, related to highway and the vesting and what vests in the Highway Authority, as does our case. One needs to be careful in my respectful submission with what the Court of Appeal is saying, because it is dealing with what is vesting in the highway, and highway is used in a way which is meant to mean the property which vests in the Highway Authority. And the point was made earlier this morning that highway can mean the physical way as well as the right across it. But in any event, my submission would be, even if the court were against the Court of Appeal on that rather focused approach, it makes no difference if, as we say in our case, the court comes to the same conclusion when looking at what vests in the Highway Authority by virtue of being Highway Authority, as opposed under the other functions provisions of B. Can I just, again, draw attention to the explanatory notes at 377. The other aspect of the purpose can be seen, which is the creation of roads as GLA roads and the removal of a significant number of trunk roads from London and passing of those to the GLA. And although it's not necessary to take the court to them, but if the court wished to see the schedules to the designation order, which were made shortly before the property transfer order, show a considerable number of the trunk roads within London transferring or being designated as GLA roads. So that purpose is obviously carried through. Just while I mention the designation order, for the sake of accuracy, although my learned friend made some submissions about proposed highway, no proposed highways were designated by the order, and therefore the transfer of property order did not have to deal with proposed highways. There's another provision.
And we don't have any help. I mean, I raised with earlier the question of what happened back in 1985.
Well, I wondered whether your lordship might ask me that. We did put in the. Your lordship will recall, because I recall your lordship striving with the property order. There was a second property order, your lordship may recall.
No.
The property number 2 order. It's probably mercifully been blanked out. What's interesting is...
I mean, don't take up time.
No, but the short answer is this. The highway authority functions were transferred to the boroughs and metropolitan roads were abolished. It was thought necessary, although the highway functions were transferred, and so Section 263 would have come into play, it was considered necessary specifically to transfer the subsoil. And the property number 2 order, which is in Volume 2 of the authorities, tab 12, memory stick 1589, specifically transfers the subsoil separately. There are a certain number of narrow exceptions in Schedule 2, but there's a specific transfer of subsoil.
Yes, that had slipped my mind. But it is quite interesting to see that.
Yes.
How it was done.
And I'm going to develop the 19th century points about the 19th century authorities in a moment. But my submission is going to be this. The statutory context in which the 20th century statutes have been produced have always been on the basis of the Baird approach. If you look at the Reading Committee report in 1959, you've seen one passage, I'll show you a couple of others, there is no suggestion that highway vesting, even with trunk roads, was on any other basis. And if I can take, at this point, my leave back to the 19th century, I'm sure the court's delighted to be looking at more of this, but can I just draw the court's attention to the statutory provisions? They can be done briefly because they're all in more or less the same form. If the court would please go to bundle 1, tab 4, page 1321 of the memory stick.
You say 1321?
1321.
Thank you.
The phrase, so the key phrases are all present and future streets being or which at any time become highways within any district, and then there's reference to the materials. 4th line, shall vest in and be under the management and control of the said local board of health, and then the duties of the local board of health to repair and maintain, etc. This is the first provision which refers to vesting of highways. And although street is used, it's streets which are highways. And it's present and future streets. Prior to that, as my learned friend has said, it was simply control and management and the duty to repair. The Metropolis Management Act, 1855, which is touched on by one of the cases, is on the next page, 1322, tab 5. And the key phrase, not identical, but substantially similar, bottom 6 lines, all streets being highways, and then reference to the materials, shall vest in and be under the management control of the vestry or district board.
Sorry, where is this?
I'm sorry, my lady, it's page 1322. Tab 5.
Let's see, it's the last half dozen lines.
It's the bottom 6 lines. The Public Health Act, you have already seen the wording of that, but it's on page 1323, and it can be seen that it is in similar terms to the earlier statutes. When we move into there are many other highway statutes which no one considers it necessary to trouble the court with between 1875 and 1929. But in 1929, the Local Government Act, this is tab 7 at page 1324, dealt with the vesting of roads in the county council, making the county council the highway authority for what were then called county roads. And you have the words vesting roads and materials in subsection 2 at the foot of page 1324, going over to the top of 1325. So it's all roads in relation to which they have those functions and the materials thereof, and the drains belonging thereto shall vest in the county council. So again, you've got the 3 parts that the learned friend has drawn attention to: roads or highways or streets in the earlier statutes, vesting and the materials and the function of the highway authority.
I think it's common ground between you. Here we're talking about the 2 spits.
Indeed, and it is throughout the history of the highways legislation that the Baird principle has been applied.
Yes, to vesting, and I mean, you'll show us if that's applied to transferring property.
Presumably a principle way with section 29. One by way of transfers from some previously responsible.
That's right.
Because if all roads were previously under the responsibility
Yes,
of the local authority, then it's hauling out main roads from a previous scheme.
It is, and I don't think we thought it necessary to trouble you with the early legislation defining main roads and the authorities. The urban district councils were involved at that point in earlier legislation in the late 19th century. But
typically there will have been a road which, quotes, vested in some other authority, and then in 1929 it, quotes, vests in the county council.
yes, but of course some roads may or may not have been the subject of improvement works at the time. It doesn't draw any distinction between the vesting of roads where they may be held, including their subsoil and airspace, or where they've simply vested in terms of the zone of ordinary use. It's simply the same rule.
Yes, so you might have had one which had been acquired compulsorily by a previous authority, and as a result the authority held all the land. Then under this section you say that the only thing that vests is the 2 spits.
Yes. And when you come then to the Highways Act 1959, my learned friend has rightly pointed out, this is the first piece of consolidation of the acts. And again, we've not troubled the court, but Schedule 25, which are the repeal section, which we haven't included, but we can provide it if necessary, shows the wide extent of the repeals back to the 16th century, but including most of the statutes that you've seen already. And those referred to in the Baird line of cases, they're all consolidated at that point.
Does Pratt and Mackenzie get looked at all nowadays? That used to be the sort of textbook on the 59.
It doesn't appear to assist. I think both my learned friend and I have looked at it at various points. The Reading
And
Committee
this would be
report-
consistent with the case we looked at this morning about Regent Park Road, the former turnpike.
the Turnpike, yes.
Yes, where all that vests when a modern local authority takes over responsibility as highway authority is the
Zone of ordinary user, yeah.
Yeah.
Yes, the Turnpike trustees retain the remainder of the freehold, even though they were effectively the authority for the road before that, albeit under separate legislation. And my lord, I did see if we could get you a copy of the 1822 Act. I can see
I've had
Lady
a look
Hales
at it.
looking fascinated by
I've had a look at it online, and I think there is specific provision which enables the trustees
unfortunately,
to sell.
the National Archives say it hasn't been digitised and therefore it's not available for download.
Well,
I've only managed,
Well, quite a
You
lot
managed
of
to
it,
find
quite
it?
a lot of it's there, yeah.
yeah, I managed to find some specific provisions. Whether they're the correct provisions, I'm not sure.
But I mean, what it did seem, and I mean, again,
Well, we can certainly look at it in hard copy
I'm sure.
in a room in this very building, so
As
it's
long as
not
it
a
doesn't
problem.
have to be carried to you on vellum rolls.
I doubt if this case is going to turn on.
I don't think so. But it's a correspond. It may not be precisely on point because of the turnpike legislation, but it is an analogous concept that the Highway Authority doesn't get it just because the previous owner got it. And there's no suggestion that a different approach was adopted towards local authorities transferring between each other, for example, in the 1929 Act and in the 1959 Act.
And the trouble is that, I mean, as you said in opening, this is a very specific problem in London, and particularly in the city, where there's a sort of whole range of different layers of use.
Well,
Whereas in most parts of the country, it probably isn't a major problem.
no, it's to say that there are issues in Southwark as well. But that's correct. The point I'm just seeking to show the court is that a consistent approach has been adopted to what vests as highway in the Highway Authority, to the extent you're using it as a property right. And I do bear in mind, particularly when I come to my learned friend's points on 265 and the phrase at the end of section 1, highways and other property, that of course in Coverdale and in subsequent cases, Rolls and the like, the Court of Appeal made it clear that of course what vested in the Highways Authority, Quay Authority, was property. And that was the basis upon which they could let out the pasture in Coverdale. So its inclusion as a property right takes my learned friend's argument nowhere, because no one disputes that the zone of ordinary user is a property interest, and indeed, as I've already submitted, is an overriding interest for the purposes of the Land Registration Act. And indeed, you have, although we didn't go to it and I don't propose to now, the Runcorn decision, where Lord Evershed went in detail through the Law of Property Act, making it clear why a determinable fee simple of indefinite character, of indefinite extent, was nonetheless preserved as a fee simple, although it was within the Section 1 definition. And his view was it fell within the exclusion of Section 7, other similar cases to the Land Clauses Consolidation Act. And that's been the basis upon which highways been understood to fall within the concept of legal estates since that decision. I was going to the Reading report on the consolidation, which is in volume 3 of the authorities bundle. Tab 33.
We're going to come back to the Trunk Roads Act, 1936.
I will. It is notable, if my learned friend is right, that what became section 265 was excluding Baird, that no mention is made of this in the Reading report. And the court has already seen the terms of reference of the Reading report at memory stick page 2114. Amendments not of substantial importance were to be recommended where they were desirable. There's no suggestion at all that the principle that's set out at paragraph 135, page 2163, learned friend read out, relating to the vesting of highways. When you come to consider section, what was then clause 227, that any different approach was taken. The only reference I think we have to 227 is on memory stick page 2176, where the committee is running through the clauses of the bill. And 227 preserves the distinction between trunk roads and other highways because of the ministerial provision in my respectful submission. There it says the purpose of functions in relation to the highway under the enactments mentioned. Part 1 contains a number of enactments modified in relation to trunk roads, reproduced in the draft bill. Property vested in a local highway authority for the purposes of functions in relation to a highway under any of these clauses will therefore be transferred. And that's, of course, what is now section 2651B, the equivalent of article 21B. So there's no suggestion at all by the Reading Committee that it considered highways vesting in terms of trunk roads as being any different from any other form of highway. And the highway purposes point is specifically directed at the equivalent of Article 21B.
It seems to assume that the test is whether the property is vested in the authority for the purpose of functions related to a highway.
That's the B point, Lord, because Clause 227 had the equivalent of what is now Section 2651B in it. I ask your Lordship just to go back to the bill in the previous tab. And it's page 2105. And that's in substantially like form than it became as 228, and indeed you'll see it's in very similar form to 265, if not identical.
Sorry, you're now on the
2105, the trunk roads clause that was being commented upon. And the point I was going to make was the purpose of the function relates to B, and your Lordship will see it in 2271B1 and 2, as you see it in 2651B.
Yes, but my point was that the commentary on page 2176 is not distinguishing A and B, is it? It's treating the whole thing as being...
Well, it's referring to property vested in a local highway authority, and that, in my respectful submission, does take you to 2271B.
We don't... do we have Section 7 of the 1936 Act?
I don't think we do. We might do. We do, yes. Section 7 is at page 1338. If your Lordship wishes to go to that now, I'll come back to 227. It's Bundle of Authorities 1, tab 8, 1338.
That's quite differently structured.
It is.
And what it does is to make the governing requirement that before the relevant date it was vested in the former property for the purposes of their functions, i.e., as I would summarise, as such. It's the road and any land, so it sort of includes A and B.
Well, it's when a road becomes a trunk road, subject to the provision of this section, of the property which immediately before, and then at A, you get the road and any land. As your Lordship has pointed out, it combines A and B.
Yes. But all within an overall control about the purpose for which. Yeah.
Although, of course, the trunk roads that were being designated under the initial 1936 Act were highways vested in previous highway authorities that were then being taken over for national purposes. So, again, there's no suggestion that it's taking a different line to the Baird approach, which, of course, would dictate what was vested in the highway authorities from whom the trunk roads were being created and designated as the minister's responsibility.
But I think the only point on this, what we're looking at, which is the 1959 committee, don't seem to be envisaging a change in the fact of what was happening from the Section 36 Act.
No suggestion that it was seeking to exclude Baird. Well,
Well,
My learned friend places...
Exclude or include?
no suggestion either way, I think.
Well, no, what my learned friend says is it's of considerable significance that Baird, he says, is excluded by section 262. That provision was also there as 225(2). Sorry, it wasn't 2252, 2251A in the 1959 Act. And you would have expected that exclusion to have drawn some attention from the committee, bearing in mind that its remit was only to make minor amendments.
Well, we can make what we will of it. Anyway, I mean, what you're, I think, accepting is that there's no suggestion that clause 227 was intended to change the law materially from 1936 Act.
My submission is the 1936 Act wasn't intended to depart from the Baird principle.
No, I understand that, but whichever way it went,
Whichever way it goes.
carries on.
Yeah. But can I just come back to answering your earlier question, my lord, which was in relation to property and purposes.
Yes.
The sentence at the end of the paragraph I'd referred to on page 2176, the reason I say it's clearly referring to B is because B opens the property mentioned in the next section, the property which immediately before the said date, and then refers to functions. So it's clearly a paraphrase, in my respectful submission, of 1B of the bill, rather than being a general point.
Yeah. So, assuming that, as seems to be the case, that 227, Section 227 of the 1959 Act was meant to have the same, was understood as having the same effect as Section 7 of the 1936 Act,
Yes.
then really one sees in B of 227 an express reference to property being vested for a transfer of property vested for the purposes of their functions in relation to the highway.
Yes.
One doesn't see that expressed in relation to A, but it's presumably on the footing that it's unnecessary to say that expressly.
Because the zone of ordinary user will transfer under A, which is the primary basis upon which the highway authority is holding as highway authority. That must vest in it by virtue of its being a highway authority.
Yeah.
Well, it could be limited to the zone of ordinary use, or it could be limited to being held for the purposes of the highway.
Yeah.
Could be either of those.
Well, except
for your principal argument.
and also because the committee was separating out, presumably on the basis of their understanding, the transfer of the highway, which was vested in the former highway authority, and the property held for the functions of the highway authority in that road.
Yeah.
Separating it as A and B, whereas it had been combined in the 1936 Act, in Section 7. And as I've already submitted, and forgive me for repeating it, it would have been a significant change in my respectful submission for the Reading Committee to be recommending a departure from the acknowledged position in Baird, which, as my learned friend says, results from the purpose of the statutory provisions, which I say is the same as the purpose here, and yet not to mention it.
Yeah.
Sorry. You're all asking too many questions. I'm asking too many questions. Sorry. I'm very troubled by, and I think the thing that troubled Mr. Mayle, that we're trying to look at a sort of general statutes, where the real problem we're talking about is very specific to the centre of London city. I'm wondering how I can actually answer these questions without looking at the factual situation in a section of London where you have all sorts of things under the surface.
My Lord, to which my answer, as it was to the arbitrator, goodness, 4 years ago now, is that is dealt with under B. Your factual inquiry...
I understand that's what you say, but
well, it works.
I mean, surely the best thing would have been for the arbitrator to get on and look at the particular properties that you're really fighting about, rather than trying to get some sort of general solution.
Well, as your Lordship can imagine, the hope was that we would now narrow down the area of dispute. He says 4 years later, standing in the Supreme Court. But can I say to the court, there is no gainsaying the enormous task that faces the arbitrator in due course, which was why he agreed to the preliminary issues. There is a huge range of factual dispute, and as you can imagine, in particular in the city, actually obtaining information about the vesting of roads and properties and the purposes for which they're held is somewhat difficult. I think I was told that the information with regard to registered land in the city has been passed over to TfL, but the position with regard to unregistered land, as you can imagine, is complex to a very high degree. And it's added to by the complexity of the fact that the City of London, not Southwark, of course, is a private corporation as well as a local authority. It's the only local authority which also has its private capacity. So it's a complex process on any basis. And in my submission, the way Parliament set this up was to apply the 265 provisions to London. As I've shown the court in the explanatory memorandum, that was against the acknowledged background of the existing legislation. No suggestion that the purpose of the Act was to change the direction of the existing legislation, but it was set in that context, and that the factual inquiries are appropriate to be dealt with in such a complex situation under B, and there exists therefore very good reason, if there were not ample authority in my respectful submission to support it, to explain why A should be restricted to the zone of reasonable user, the zone of ordinary user, and that B then is the point of inquiry for the rest, bearing in mind the complexity here. There is a great peculiarity which arises from, if not difficulty, from my learned friend's argument, which is in relation to a provision which he didn't touch upon, which the Court of Appeal did, which is section 266A. And can I explain what that is and then take you to the provisions? There are a set of provisions in the Act which unsurprisingly allow the GLA to review the designation of GLA roads after this initial tranche. This only concerns matters designated by the Secretary of State before the Mayor was elected and the GLA was up and running. Under section 14B, if I can ask the court to go to that, please. Bundle of Authorities 1, tab 11, page 1445. You will see that under 14B, there's a duty on the Mayor to keep under review the system of highways, and subject to considerations of expediency, he may either propose a new GLA road designation or de-designation under 2B. Parliament set up a procedure in the Act which did not require the making of any further property transfer orders or designation orders, other than the designation by the Mayor under 14B. What it provided was another statutory provision at page 1539 of the memory stick, section 266A.
So which page?
1539, my Lord.
Yes, I've just been looking at that.
And it's peculiar, I said peculiar deliberately, because it omits the equivalent of A. Mm. And if, I'm not a betting man, but if I had to pin my colours to the mast in this respect, I might submit to the court that the inclusion of little a in the order was for the avoidance of doubt. Because, as my learned friend submitted on many times below, 263 would transfer the highway area of ordinary user in any event, regardless of the order, because by virtue of the designation of the new highway authority, it would vest automatically. That is clearly the approach the draftsman to the statute took to 266A, which is in broadly the same form as the designation order, that is to say, modelled on section 265, but it doesn't include A. So one goes immediately to B.
Of course, you have a different draftsman.
Well, which is why I say it may well be the case that 21A was included for the avoidance of doubt. The draftsman of the order may have thought, and I've speculated on this in the courts below, and no real conclusion is reached by speculation, but it appears to be an abundance of caution, possibly because the GLA roads were being designated from two sources, the borough roads and the corporation roads and trunk roads. And the trunk roads provision excluded 263, and the draftsman doesn't seem to have noted section 2657, which operates in reverse when something ceases to be a trunk road. But it may be simply the draftsman of the order decided out of an abundance of caution to leave A out. Under 266A, where the mayor designates further GLA roads, it's plainly, in my submission, reliant upon section 263. Because all one has is at 2A and B, the properties and liabilities which are referred to in 2.1b of the order, with the same provisions about liabilities and exclusions are set out in 4 as they are in 2.3 of the order.
But why wouldn't 4A, the reference to land, include the highway itself?
Well, one could make the same point about the order. It's what I said earlier, my lord, that if my learned friend is right, then the land. That if what my learned friend says is right, you don't need A in any event, either because of section 263 or because B is broad enough to include it. Because B is property, any property which has that functional link with the highway.
But I'm just testing your proposition that the way 266A works is to rely on 263 for the road. Why doesn't the road fall within 4A?
Well, it would be an oddity for the statutory draftsman who
it's
has
odd.
made provision for vesting under 263, under 265 and under Article 2, although, as my lady says, probably not the same draftsman for the order, probably drafted within the department. But 266A then doesn't mention vesting in terms of the highway. And in my submission, the difference between 266A and the order is explicable on the basis that Parliament assumed 2631 would apply because you're not designating a trunk road, the exclusion doesn't apply. And if that is right, and I appreciate it's based on that line of argument, if that is correct, and Parliament was intending that subsequent reviews of GLA roads should rely on section 2631, that would introduce a distinction between my learned friend's construction of the order for the initial tranche of roads and the effect of the subsequent designation of roads under 266A, under 14B, and then the operation of 266A. You wouldn't need the equivalent of 265 because 263(2A) exclusion only applies to trunk roads under 265, wouldn't apply to GLA. It doesn't apply to GLA roads. And so if one assumes a relatively even approach to drafting, even with provisions included at a later date, that there's always a vesting provision, then in my submission it is odd that it's not included here, and I've made my submissions as to why that is.
Is this a point in your case? Or?
The 14B is, I
No,
confess,
just that I'm trying to get my head round it. I'd quite like to see it written down.
can I confess that I forgot to put it in the case?
I
did argue it in the Court of Appeal.
No, but by all means do it overnight, but
I'll happily put that
I'd
in.
quite like to see it spelled out.
I apologise. It was one of those things that when reading the case, I couldn't recall why we omitted it. The other issue which arises is the reverse position. If it's de-designated as a GLA road, then there is nothing to pass back the wider extent that is vested under Article 2.1a, if my learned friend is right, because there is no equivalent provision in 266A. These provisions are intended to apply to both designation and de-designation, as you see from the end of subsection 1. So it would mean that property that had passed under Article 2.1a, which didn't have to satisfy the function test of B, would not go back necessarily to the authority on D designation. And again, that's a potential mismatch in the provisions, which doesn't occur if you simply treat Article 2.1a as for the avoidance of doubt provision, seeking to replicate 263 and omitting to recall that 2651a was only required because 263 was excluded from truck roads. That, in my respectful submission, is a simpler explanation and accords more with one's experience of statutory drafting than perhaps my learned friend's approach. It also leaves, as I've already submitted, the factual issues to be resolved by the arbitrator if they can't be agreed. Let us hope that many of them can be agreed under the B provisions or their equivalent. That would then mean that the provisions which apply following the initial tranche of designations and vesting, that is to say 14B and 266A, would have the same effect, in my respectful submission, and wouldn't leave a gap either in terms of A being omitted, either in terms of designation, or if the matter went by virtue of D designation, when it reverts back to the earlier highway authority, because it would then go back to the boroughs or to the city corporation. Sorry, I've lost my note. Where's it gone? I can deal briefly with the Bayliss case on section 265. My learned friend submitted it was a matter that wasn't argued. That is supposition on his part. There was certainly, I'm not going to go through the details of the case. The court is, I'm sure, well able to read it, but the court will see that there were a significant number of arguments on highways and on highways history. It seems unlikely that the learned deputy judge in that case would have simply plucked these matters out of the air. And indeed, what is notable, I mean, learned friend said, well, it's not clear he was dealing with trunk roads. It's plain he was, because if you look at the footnote on the pages he's referred to, it specifically references what was then section 228 and what the deputy judge pointed out was now section 265. So it's referenced in the footnote. In my respectful submission, Mr. Lewison, as he then was right to apply Baird to 265 for the reasons I've already indicated. Can I also just add to my submissions a point that arises on the goods case, the judgment of Lord Hoffman, which my Lord Carnworth mentioned in his Mitchell judgment, which is to say, in the passages that my learned friend took you to, the final paragraph under heading 6 makes it clear that the court was considering the matter in the context of legislative history, and he noted, this is page 2228 for reference in the electronic bundle.
This is a supplementary.
Supplementary bundle.
What's the
It
Starts at page 1,
yes.
so it doesn't follow on consecutively.
So what would the number
But I can
be?
probably get it from the index.
I'm afraid it came to me with 1, 2.
I think it's got an auto. No, the index is in a separate separate attachment, so that doesn't take you to the content.
I think it might be page 6. Counting. 5 or 6.
5, I think.
Afraid it came to me with electronic numbers on it.
So what
It's 7. The case starts at 7.
7. And if I can,
goods, yes.
so if it's easier to take the internal page numbering of the law report, 1360. Lord Hoffman makes at letter H a point which in my submission applies with as great a force as it did to the maintenance issue to the vesting provisions, where he says it's impossible in construing the Act of 1959 to shut one's eyes to the fact it wasn't a code which sprang fully formed from the legislative head, but built on centuries of highway law. It's quite a nice turn of phrase, but the point is, of course, is that looking at highways law, particularly since you've got two consolidating statutes, 1959 and 1980, to look at that against the background that my learned friend and I have referred you to, but with the addition of my submissions, which say the reasons which led to the narrowness of the interest vesting in the Highway Authority in the 19th century cases apply today, and that issues with regard to wider land holdings which may exist as a result of compulsory acquisition or acquisition by agreement are resolved at the sub-point B stage, rather than in terms of marking a dramatic change from the law and the Baird principle, which there's no basis, in my respectful submission, for doing, having regard to the consolidation provisions. I might point out that my Lord Carnworth made a similar point in Mitchell as well, which perhaps really begs the question of, well, what do the 19th century cases decide, and how does that bear on the current situation? I've made my submissions that there is a consistent line of approach based on Baird. There's no suggestion that trunk roads were based on any other provision. The fact that new trunk roads may be the result of compulsory acquisition may make it very easy for a highway authority to make the B argument in relation to functions, and that may be the case in a number of instances in central London when the factual issues come to be resolved, but it doesn't provide a reason for not grappling with the particular issues which arise if you vest more than the highway authority got pre-legislation in 1959, that is to say, the Baird principle. In my respectful submission, the history of what vests in the highway authority, because of its functions, including its function of maintenance, apply to the modern legislation. The Reading Committee didn't think it was necessary to engage in any more complicated definitions. It didn't think it necessary to note that trunk roads were not subject to the Baird principle. And in the context of the remit and the consolidating role of the statute, applied again in 1980, in my submission, that silence is significant against such a well-established background of authority in the 19th century. It's also perhaps noteworthy in terms of the difficulties which are said to face highways authorities if the whole vesting approach isn't adopted, as my learned friend argues, is that in terms of the repairs cases, as my Lord may recall from the Mitchell case, when I think a case called Sandgate, which is in the bundle, was cited, which didn't seem to have been cited to Lord Hoffman in Goods, the vesting of the area of ordinary user, the top two spits, was never seen as restrictive of the duty or power to maintain. And my Lord may recall that involved a sea wall and groins adjacent to the highway, where the House of Lords made it perfectly clear that the duty to maintain could not be restricted simply to what was vested in the Highway Authority, but may well be wider than that, and they may well seek contributions for repairs wider than that. So it was never seen as restrictive of the power of the Highway Authority to be able to discharge its functions. Its functions, of course, as in the case of vesting, helped in understanding what its duties to maintain included. And
can I just,
yes,
related to that, I'm still trying to get my head around what you say is the interest you retain once if you're trying to exploit the air rights, which seems this is probably what this is all about.
Well, it isn't. It's also, there is an issues to lateral rights as well,
All right, yeah.
which may flow from this.
Yes, but whatever you're trying to exploit, you need to be clear what interest you have, which you can sell to a commercial developer. And it does seem to me that on your construction, where the sort of zone of responsibility is a very fluid concept, you're never going to know what it is, and someone dealing with you is never going to know what it is you're able to sell them.
Within reason, my lord, but you get a much clearer answer under B, because there the arbitrator has to make a finding of fact as to precisely what should vest as a result of the functional link with the highway. And that achieves certainty with regard to land which isn't vested immediately in the Highway Authority.
I see. So following the arbitrator's decision, you will then have clarity exactly what you...
Yeah.
Will that apply to a flying freehold?
Well, it may do. Can I just show your lordship one of the problems that arises with... I'm trying to add some sort of local colour to this, but can I ask your lordship to get, or the court to get out Miss Barker's witness statement, which is in Appendix Part 2C.
I feel sure you've got an MS number for that.
I have to apologise, and that I'd wrongly assumed that the bold numbers on the bottom were the MS numbers, and clearly they're not.
They usually aren't.
Can I...
So what do you want to
What page in the bundle?
It starts at 818, which is Upper Thames Street. And you see an illustration of the sort of issue at 822, where you've got a tunnel and a bridge and buildings on top of it. More particularly, the concern of the city is in the city school, which also straddles... Sorry, it starts at 818, and the photograph I was referring to of the tunnel is at 822, and then you have the City of London School at 831, 832, which are on a raft above the road.
It's 2C.
Just illustrative of the sort of problems that arise.
Yeah.
And why the position is complex, whatever approach you take. I'm not suggesting that the school necessarily goes to TfL. It's vested in what's called City's Cash, which is the private arm of the corporation. But the issues can easily arise if, for example, the highway has been amended as part of a planning scheme for redevelopment. As the court, and I know my Lord Carnwath will know, compulsory purchase orders can be made under the Planning Acts for regeneration, which may include elements of roads within them. It doesn't follow that, that the title to land necessarily comes through the highways route.
Does TfL have wide powers to exploit land for commercial development?
Yes, it does. And it's fair to say, my Lord, in defence, that the commercial motivation isn't lost on TfL, which is why it is pursuing this appeal, no doubt.
I mean, I just wanted to be clear that when you both have suitable powers...
But if I may throw a very gentle brickbat, the arbitration set out with TfL also seeking to acquire the land vested in the city by virtue of its private capacity, and that's the final limb of the arbitrator's decision in my favour. It's clearly... And no one's suggesting that all three authorities are not motivated by concerns over valuable assets. TfL is, and undoubtedly Southwark and the City of London are. But it's the sort of difficulties that can arise, which are shown by the complexities here, not just the shooting gallery under Blackfriars Bridge and the Victoria Embankment. The issue, therefore, with regard to the extent of what other land vests, whether it includes the whole of the column of airspace or whether it stops short of a construction which goes over the road, such as the buildings you've seen in those illustrations, or the school, those can be determined by the arbitrator under B perfectly simply and certainty achieved. And there's no irrationality in my submission, in our approach to construction, which includes the ability of the arbitrator to resolve those issues. The extent to which greater complexity is created, the learned friend says, is going to be aggravated by this approach because it will divide titles. Well, in my submission, that is likely to arise in any event if, as is the case under 2.1b, slices can be taken, for example, for items within the title of the highway, but say beneath the soil, which are not being used for highway purposes, or items above the highway, such as the constructions I've shown in the court this afternoon. Those complexities are going to arise, and in my respectful submission, those issues weighed far too heavily with respect on the arbitrator and Mr. Justice Mann, because you were dealing, as the Court of Appeal recognised, with an inevitably complicated situation, and Parliament has sought to steer its way through that by using provisions which allow the arbitrator to make a decision once you get over the issue of the ordinary user zone, to make a decision based on the facts. And that, in my respectful submission, is a far satisfactory position, a more satisfactory position than having either an automatic vesting of everything and then leaving it to the agreement of the Secretary of State and the authority, which doesn't provide any comfort at all, because the Secretary of State may be otherwise engaged or unwilling to discuss those matters. And as was pointed out by my learned friend in response to Lord Carnwath earlier, the arbitration provision doesn't entitle the arbitrator to make an exception and require agreement. He may be able to deal with the consequences of a lack of agreement, but he can't require agreement. What's important is what the provisions actually vest and what the arbitrator has discretion to determine according to the facts. The fact also not considered by my learned friend, which is important, is the Baird principle also carries with it the indefeasibility of the highway and its ability to revert should the highway be stopped up. And the court has seen the authorities. There's no dispute with regard to the principle. There are concerns which might arise if there has been dedication or adoption by agreement under Section 38 within London as to what might happen in terms of GLA roads and which have been adopted by agreement or by operation of dedication agreements or implied dedication through long user. Whereas application of the Baird principle, on which Parliament appears to have proceeded, would vest the narrow determinable interest mentioned. If Article 2.1a has the meaning TfL attaches to it, it may mean that far more has vested than anyone expected. And in my respectful submission, that lack of certainty and that it goes to the question of the reasonableness of the construction which is put forward by TfL. Also, with regard to TfL's submission that difficulties might arise in future, and you have the diagrams of increasing complexity, not including flying taxis at this stage, but one can see that in the fifth sheet as yet unproduced. The other thing that's important to bear in mind is that in the context of the limited vesting provision, which has been the basis for highways authorities holding of property since the mid-19th century, Parliament has created increasingly complicated and broad powers in highways authorities to do other matters, including acquisition. And I simply draw the Court's attention to the fact that there are wide powers under the Highways Act and other acts. We put in our Annex 4 to our case, and I don't need to take the Court to it, but Annex 4 to our case contains an illustration of the powers available to a highways authority even when it doesn't have ownership of the areas over which it is seeking to exercise powers for the benefit of the highway. And that includes building subways, bridges over the road, and other such matters. So even the lack of vesting of the subsoil or the airspace does not prevent it having powers to put in footbridges, for example, if they're considered necessary for public safety, or subways beneath the road and the like. And if all else fails, they have powers of compulsory purchase. And those are contained in sections 245 and 246 principally, pages 148 to 146 of the memory stick bundle. I don't ask the court to turn them up. They're statements of the obvious. They've got powers in relation to a whole series of matters in relation to the highway, including their improvement, construction, and enlargement, and for making ancillary provisions to mitigate the effects of highways. So if the building of a highway has adverse effects on an adjoining landowner, mitigation provisions may allow compulsory purchase as well, and they fall within the provisions I've mentioned. So TfL's plea to the issue of the difficulty in future is met by saying that future difficulties can be resolved by the existence of the wide panoply of powers under the Highways Act in any event. Milady, other than the note I've promised Lord Carnwath, I'm not sure that there is anything left I wish to put before the court, because the rest of the submissions are set out in detail in our written case. That is the heart of our submissions with regard to this matter. As I said to Lord Carnwath, I'm happy to produce that note overnight.
Well, that would be undoubtedly helpful to produce that note overnight, because it strikes me as a rather important point, which you seem to have omitted from your original case.
Can I, in my defence, show the court where it appears in the Court of Appeal's judgment?
The Court of Appeal has made this point.
Yes.
Yes.
And I did make the point to the Court of Appeal.
Yeah. No matter, no matter. Well, you're inviting us to adjourn now, I take it.
Yes.
Perhaps we won't treat you as having finally concluded your case, in case something occurs to you overnight, or your learned junior sort of tugs your sleeve metaphorically, and then we'll hear Mr. Morshead's reply tomorrow morning.
Yes. Just before the court rises, the point about 266 appears in paragraphs 49 and 50 of the judgment of the Court of Appeal, memory stick 153, 154 in the core bundle. But I will set that out. I apologise for its omission.
Thank you.
I will check also whether I have any other matters arising from Mr. Morshead's oral submissions, but I suspect I've covered most of the ones I need to cover.
Well, thank you very much indeed.
Thank you.
We'll look forward to hearing from both of you tomorrow. Court will adjourn now.